Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back to a law that we have paid very careful attention to because there has been mounting constitutional challenges to it since the issuance of the Bruin opinion by the United States Supreme Court in the summer of 2022. Specifically, I'm talking about 18 United States Code Section 922G3, the prohibition on those who use unlawful controlled substances from possessing a firearm. It's a very unique law that bans possession by people at all times for even occasional usage. Well, as you know, there is a significant challenge underway, and the Department of Justice had an opportunity to back off, but apparently they don't want to do that. So today, let's spend a few minutes and let's talk about the stupid gun law that DOJ won't back off of. Okay, America, what we are talking about today are cannabis users and their inability to possess a firearm. And yes, this is a big issue. I know that many of you don't think it is a big issue, but I think it is because there is a multitude of states that have now legalized cannabis. I view cannabis much the same way that I view alcohol. And therefore, I recognize that the law should not permit a person to be in possession of a firearm while they are under the influence of cannabis. Just like most states have laws that says you can't be in possession of a firearm while you're under the influence of alcohol. But for whatever reason, when it comes to 18 United States Code Section 922G3, yeah, if you use any unlawful controlled substance at any time, theoretically, you are ineligible. The challenge that we're talking about today is a case that we've talked about before. It's United States versus Daniels. Daniels was caught with firearms in the car and some roaches. Translation, some expired marijuana joints, okay? He liked to smoke his weed and he liked his guns. That's who Daniels is. He was charged in federal court, convicted, and sentenced to 4 years in prison. Now, Daniels challenged the constitutionality of 18 United States Code 922G3 at the district court level and prevailed. The United States government, of course, crapped its pants and appealed to the Fifth Circuit. But guess what? The Fifth Circuit affirmed that ruling, finding that there was no historical precedent to disarm an individual merely because they occasionally use a controlled substance. The United States government again crapped its pants and appealed to the United States Supreme Court. The United States Supreme Court issued its ruling in United States v. Rahimi, and then GVR granted the review, vacated the ruling, and remanded back to the lower court, to the Fifth Circuit, for a ruling consistent with its holdings in Rahimi. Which, shockingly to nobody, the Fifth Circuit upheld its previous ruling, and as a matter of fact, Rahimi really just reinforced it. So now the United States Department of Justice, under Pam Bondi, a new and improved Department of Justice, had an opportunity to walk away from this case. Did they walk away from it? No, they didn't. No, they didn't. Despite the fact that they requested an extension of time from Justice Alito to file their memorandum in support of the petition, and many of us had actually hoped that the Department of Justice was just going to walk away from this issue. Instead, what they have done is they have, in fact, filed a petition for certiorari. But, and this is maybe where the new DOJ ain't that different from the old DOJ, what they're telling the United States Supreme Court is hey, listen, accept review of this, but then just put it on the back burner. Put it on hold, because we have another case that we've filed for a petition on, and that's the one that should be the controlling case. That case is United States versus Hammani. Now, what's different between Hammani and Daniels? Well, the allegations against Daniels is that, well, he likes to smoke a little weed here and there, and he also likes his guns. And that's about the allegations standing alone. Hammani, on the other hand, his case went all the way to trial. And what it showed is that Hammani likes to routinely drive in an impaired state. He is basically a DUI in perpetuity. He also is a big fan of the Iranian government. He is a big fan of Iran in general, and he is not a fan of the United States of America, and has made that publicly known on social media. As a matter of fact, Mr. Hammani has been, let's say, very, very pro-terrorist, even making statements that if one of his Sharia brothers was about to kill innocent people, he wouldn't say anything. His mother is even also quoted in a news story as saying that she hopes her son someday will become a martyr. So, right away, you got to take a look at what the Department of Justice's strategy is here. Well, you have one guy who's merely a pot smoker who likes his guns, and then you got another guy who's closely affiliated with a terrorist country, an individual who publicly outcries routinely in opposition to the United States of America and in pro-terroristic type fashion. So if you're a judge and you're trying to decide, geez, who should I disarm? You either have the pot smoker or the person who sympathizes with terrorists. So when we sit there and we talk about the Department of Justice having this new look and feel to it, it may be the case in some instances. But when it comes to 18 United States Code Section 922G3, no, it appears that this Department of Justice is willing to do just about anything to make sure that that law is upheld. Now, understand that this is an as-applied challenge, which is the law constitutional as applied to the facts of Daniel's case? This is not a facial challenge, which is basically, tantamount to throwing rocks at the moon. Hammani is also an as-applied challenge. And so what the United States Department of Justice is saying here is, hey, listen, go ahead and accept Daniel's, put it on the back burner. Let's let Hammani decide the whole issue. As the Solicitor General for DOJ wrote in his memorandum, Hammani would be a better vehicle than this case for deciding whether Section 922G3 complies with the Second Amendment. Hammani cleanly presents that question. There, the Fifth Circuit squarely held that because the government's evidence was deficient under the constitutional standards set out in United States v. Connolly, Section 922G3 violates the Second Amendment as applied to the defendant. The Fifth Circuit's decision in this case, by contrast, involves a procedural wrinkle. The court recognized that the evidence may have satisfied Connolly's standard, but determined that the district court had committed an instructional error that caused the government's burden of proof to be too low. And that's really important because what the issue is in Daniels, to some regard, is that because the jury was not instructed that they had to find that Daniels was under the influence at the time the possession of the firearm took place, that there was an instructional error. And by the way, the quickest way to get a criminal conviction overturned is with an instructional error. You give bad jury instructions, it's a do-over every time. What they're saying with Hammani here is that the issue is a little bit more cleaner. It really has to do with the constitutional implications and the historical analogs associated therewith as applied to this law. This is not a procedural wrinkle, which is, hey, the jury instructions were screwed up. So in some ways, I completely agree with where the United States government is coming from. This is a better vehicle by which to decide this issue. But at the same token, they have taken a pretty normal plaintiff here and now basically made him Osama bin Laden. Daniels did not address whether the government's evidence was deficient, holding only that the jury was improperly instructed. Granting plenary review in Hammani would enable this court to focus on the basic Second Amendment issue of Section 922G3's constitutionality rather than case-specific issues concerning the adequacy of jury instructions. And so what the United States Department of Justice is asking for here in United States v. Daniels is this court should hold the petition for a writ of certiorari pending the disposition of the petition in United States v. Hammani, filed June 2nd, 2025, and should then dispose of this petition as appropriate. So, this sword kind of cuts both ways. Is Hammani a better vehicle by which to determine the constitutionality of 18 United States Code Section 922G3? Yes, it is, because it actually involves the constitutional application to that statute. However, and this is a big however, Hammani is the exact kind of person that you don't want armed. And no matter how stringent of a supporter you are of the Second Amendment rights, be honest with yourself for a second. Is Hammani the kind of person that you'd be like, no, no, I think this person should have a firearm. And that is the exact reason by which I believe that the United States Department of Justice has asked for this case to be the tip of the spear. Okay, the case we've been talking about today is United States versus Daniels, but you also need to check out United States versus Hammani. So we're going to link them both up down below so that you can geek out on them for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool. We want to hear all about it by you clicking on that link and telling us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.